President, General Counsel, and Director of Practice Groups at the Federalist Society. And I'm so pleased to welcome you to our first ever all-virtual convention. Over the next 5 days, we'll host over 20 panel discussions, debates, and addresses. As is typical of the Federalist Society, we'll hear a variety of views on a seemingly endless array of topics. Some might say an intellectual feast. I'm very pleased to welcome you this morning, not only to the convention, but to our first panel discussion, sponsored by our Religious Liberties Practice Group and its chairman, Bill Saunders. I'm honored also to introduce our first moderator, Judge Naomi Rao, who sits on the U.S. Court of Appeals for the D.C. Circuit. Just one quick word about her confirmation process and something I might call the typical Washington rush to judgment. In the days after her nomination was announced, I was driving to work and listening to news radio as various experts held forth about her jurisprudence, her qualifications, her background, her shortcomings, her perceived shortcomings, I should say, etc. I was surprised that so many experts could know her work so well, so quickly, but they were firm and certain in their analyses. They were so filled with insight and immersed in knowledge about their subject, the nominee, that they managed to mispronounce both her first and last name throughout their breathless reports. In reality, she has what seems like an impossibly long career before becoming judge. She's steeped in administrative law expertise, clerked for J. Harvey Wilkinson and Justice Clarence Thomas. Also served in the White House Counsel's Office and the Senate Judiciary Committee. And she has experience in big law and academia as well. She's perfectly suited to the court to which she was appointed in March 2019. I'm proud to know her and happy to welcome her today. Judge Rao.
Great. Thank you, Dean, for that really kind introduction. It's such a pleasure here to be moderating the first panel of Federalist Society's National Convention. This is certainly one of my favorite events of the year, and I'm glad the Federalist Society is going ahead with a virtual convention. I don't think even Dean Reuter has quite figured out how to have virtual hallway conversations, so I guess for that we'll all have to wait until next year. But in any event, that means we have a week where we can focus on the substance of these panels. So let's get started. Today, this panel, we're going to be discussing religious liberty, and in particular, the constitutional protections for religious free exercise. Just last week, the Supreme Court heard arguments in Fulton versus the City of Philadelphia, an important case about whether Philadelphia could exclude Catholic social services from its foster care system because the Catholic charities would not endorse same-sex couples as foster parents. The plaintiffs in the case have asked the Supreme Court to revisit its 1990 decision in Employment Division versus Smith, which held that the right of free exercise does not permit exemptions from valid and neutral laws of general applicability. Our panelists today will discuss the ongoing validity of Smith, both on historical and doctrinal grounds, as well as focus on the debate on the requirements of the Free Exercise Clause for religious practice in a pluralistic society. We have a very distinguished and experienced panel of experts with us to discuss these issues. The speakers' bios may all be found on the Federalist Society website, so I will just briefly introduce them in the order in which they will be speaking. We're going to be starting with Professor Gerard Bradley from Notre Dame Law School, followed by Professor Stephanie Barkley, also of Notre Dame Law School. And then we'll have Professor Eugene Volek of UCLA Law School. And then finally, Lori Wyndham, who is Senior Counsel of the Beckett Fund and who last week argued the Fulton case before the Supreme Court. The way we're going to work things, we're going to have 5 minutes of opening remarks from each of our panelists, and that will be followed by a moderated discussion and questions from our Zoom audience. So with that, Professor Bradley.
Thank you, Judge Rao. In Fulton, the Supreme Court won't overrule Smith. I say so not because, having been her colleague for 18 years, I know more about Justice Barrett's views of Smith than any of you do. In fact, I don't. It's that there are other pathways to holding in favor of Barronelle, Fulton, and Catholic social services, so that a majority inclined to overturn Smith won't have to do it in a case featuring the Catholic Church and its opposition to same-sex marriage. That majority, if there is one, could wait for a case with less provocative optics. Now, I hope I'm wrong. That is, I hope that Smith is not overruled in Fulton or in any other case, because Smith is rightly decided. Smith is right, even though it is one of Justice Scalia's least convincing opinions. The arguments he made there weren't cogent, and he didn't make the arguments that were. Oddly, those missing arguments were Scalia's usual go-tos in constitutional cases. One is originalism, not a trace of it in Oregon v. Smith. I would say that Smith is therefore a welcome break from the usual hash of Madison and Jefferson that the justices serve up in these cases, except that Smith was a case where it was needed, not hash, mind you. Scalia needed a critical account of free exercise's original public meaning, one which sidestepped the court's habit of imagining the past and remembering the future. In other words, Scalia needed in Smith to make the argument he made 7 years later in City of Bernie versus Florence, only longer. And that full historical essay, which showed dispositively that Smith expresses the original public meaning of free exercise, a reading confirmed by 170 years of Supreme Court precedent up to Sherbet. I think if originalism means anything, it means that Smith is sound, notwithstanding one's regrets about the results it produces in some cases. Now, the other go-to for Scalia is, of course, judicial activism. One meaning of it is where courts invent constitutional rights, as the justices did in Roe and Obergefell. Now, that's not Smith. The second meaning of judicial activism is that there is something distinctly legislative about a particular instance of judicial lawmaking. In Smith, Scalia does not make this argument, though I think he gestures at it at 2 or 3 points in the opinion, and he should have made more of it. This inchoate claim could be fleshed out more powerfully now than it could have been in 1990, because the center of gravity in free exercise has shifted so much since then. The Sherbet test was built to explode wooden conformity to arbitrary rules which disadvantage religious minorities. I doubt that it performed that task well, and the collateral costs were enormous. The Warren Court's main strategy to protect the religious fringe was to suppress the religious center. In any event, the language, structure, and content of the Sherbet test do not illumine the values at stake in the key free exercise cases today. These key cases involve what are often called third-party dignitarian harms. Think of Jack Phillips and many other cases like his. These cases are not about government efficiency or budgets compared to the religious well-being of, say, a Native American prisoner. Today's key cases are about fairness to everyone foreseeably affected by a proposed exemption. That fairness is the relevant government interest. Call it compelling or not, as you wish. The truth is that answers to questions about fairness are reason-guided, but are never logically required free choices. There are no algorithms that collect the relevant interests for the judge, values them, and thereafter computes the correct answer. The judge has to do all of that. These free choices are not applications of rules. It is not like finding that facts fall under a certain pre-established norm. When a judge makes these choices for a whole political community by making law, it defines that community in an important respect, at least where one of the central factors in this calculus, this consideration, is religion. Now, all of that sounds to me like a legislative and not a judicial task. Now I'm pleased to hand off the discussion to another Notre Dame Law School colleague, a most accomplished young scholar and litigator, Stephanie Barkley.
Thank you, Professor Bradley. It's a privilege to get to be here and to get to speak about this topic that is so important right now. And I'm grateful to Federalist Society for inviting me to be alongside these great panelists. What I'm going to talk about today is why I think at some point the Supreme Court should overrule Smith, whether or not in Fulton or in a future case. Professor Michael McConnell has argued that some of the most influential founding era theory of religious liberty flowed from the idea that religious duty trumps claims of civil society. This notion draws from theory that was relied on in the very influential Memorial and Remonstrance, and also the deep tradition of providing religious exemptions at our founding period, including to Quakers from being drafted into the military. So the argument is that religious exercise, this core protection, was understood to include the right to engage in religious conduct, even when that conduct incidentally conflicted with general legal requirements, so long as those sorts of conflicts didn't endanger public health or safety. So the arguments that have been made against this sort of view from a historical originalist perspective have been made by Professor Bradley, by Professor Hamburger. Professor Hamburger has claimed that it would have been improbable at the founding generation that they would have contemplated a judiciary with the power to craft exemptions. And Scalia cited to Hamburger's work in his City of Burns concurrence, where he later defended Smith. And Professor Bradley has some very thoughtful scholarship where he has disagreed with the idea that the judiciary was empowered to create exemptions from laws, arguing that this was something that is a judicial creation, an aspect of the post-World War II takeover of our civil liberties. One thing that I have challenged with this idea in a recent Notre Dame Law Review article is this conventional wisdom that a judicial practice of exempting conduct from statutes is either new or extraordinary. Just the opposite. It turns out that leading up to and during the founding period, the process of judges creating exemptions from statutes was widely employed and was widely accepted. Exemptions have been noted by scholars such as Professor Eskridge and Manning, who have surveyed founding era cases. And Professor Eskridge has noted that courts had, quote, no problem announcing exceptions to old broadly phrased laws where application, in quote, contradicted other forms of fundamental law. Blackstone explained that courts would rely on equity principles to accept those circumstances from legislation and avoid results that infringed on a host of personal liberties when they swept too broadly. At English Common Law, Theodore Plunkett observed how regularly judges created equitable exemptions to the application of broad statutory language. And historians such as Professor Wood and Rakoff have emphasized how judges in the early republic had attitudes that were emphatically favorable towards a willingness to bend or accept statutory language to avoid clashes with constitutional principles. The mischief rule was one particular form of interpretation that focused on the problem the legislature was trying to solve when it crafted a law, and it looked at whether or not the government was actually advancing that interest when it applied the law. In early antebellum courts such as People versus Phillips and Commonwealth versus Cronin, courts are engaging in this sort of analysis when they are determining that exempting religious objectors would not actually undercut government interests in peace and safety. Indeed, it's plausible that this sort of mischief rule would have frequently justified lower court decisions declining to apply laws to religious objectors. Note that this mischief analysis resembles modern strict scrutiny analysis in certain respects, particularly with the aspect of the test that is looking at whether application of a law to a specific scenario would actually advance the government interest. When you combine that sort of historical principle with also the principles that Professor McConnell and Laycock have written about, that early state constitutions protecting free exercise had certain qualifications generally focused on things like public health and safety, that suggests that only certain sorts of government interests were sufficient or would qualify to interfere with religious exercise. So if you have a limited set of government interests, and then courts are regularly analyzing whether or not government is actually advancing those interests, that starts to look similar in some important respects to the type of analysis courts engage in under modern strict scrutiny under, say, a RFRA regime. So one other thing that I want to talk about that's relevant, I think, for the history with respect to Fulton is that in this case, we're dealing with a unique circumstance where the government has in effect expanded to control an activity that was previously within the realm of private religious parties. 200 years ago, the Catholic Church created adoption agencies and foster care programs to deal with a yellow fever endemic that was going on in Philadelphia. You might say that they invented foster care in Philadelphia. And later the government has taken increasing roles in this space. And I'm not saying that that's necessarily a bad thing, but what it means now is that the government has said that Catholic social services can't participate in foster care unless they do so on the government's terms. And now the government is forcing Catholic social services to choose between their religious beliefs or continuing this ministry. So one question I've asked is, given that the baseline of a large welfare state didn't exist during the founding, is there any historic evidence that can shed light on the original meaning of the Constitution with this type of conflict, where government has expanded into a new space? One that I would point to is the founding era historical example involving the Ursuline nuns. Beginning in 1727, Catholic nuns in New Orleans operated a convent that included a school for poor children. When the United States completed the Louisiana Purchase, the convent fell within the boundaries of this newly acquired territory. As a result, it could have easily been assumed that this property now fell to the ownership and control of the United States government. The nuns wrote a letter in 1804 seeking clarification about the future of their ministry. And the nuns stated, "It is not therefore our own cause, but that of the public which they plead. It is the cause of the orphan, of the helpless child of want," end quote. Jefferson responded and assured the nuns that the principles of the Constitution provided a sure guarantee that the property would be preserved to you, sacred and inviolate, and that the covenant will be permitted to govern itself according to its own voluntary rules without interference from civil authority. I think it's interesting that Jefferson wasn't just making this commitment benevolently. He wrote that the principles of the Constitution required preserving this religious ministry. And he didn't think that preserving the ministry meant you get to continue your ministry only if you do it the government's way. He noted that this ministry had a sure guarantee that they would operate according to their own rules without interference from the civil authority. My friend Mark Storsley has written about examples like this illustrate that the Establishment Clause doesn't prohibit government ministries, even in the context of government funding or property. I recommend taking a look at his article coming out in Penn. And I agree. I think that these historical examples also show that there are certain spheres of liberty that the founders understood religious groups and institutions would be able to operate within, free from government interference, notwithstanding government expansion. Or at the very least, that within these spheres, religious ministries would receive thick constitutional protection. One way to operationalize that understanding would be a rule that overruled Smith altogether and allowed for a default rule of heightened scrutiny in religious exemption conflicts. This background norm would be consistent with the idea that government should justify its ability to burden religious exercise when it's expanding into spheres of liberty that the government had largely left uninhibited during the founding period. And where government can point to use of its power that actually advances an interest that was originally understood as being sufficient to limit religious exercise, such government regulation would likely satisfy strict scrutiny. On the other hand, if the court does not adopt some sort of rule that will protect ministries, even in the face of government expansion, the risk is that government could simply obliterate the promise of free exercise of religion that it emphasized recently in Bostock, simply through its reality of never-ending expansion. All the government would need to do is license or exert control over a new activity and then condition religious groups' continued participation on their willingness to forfeit their religious beliefs and practices. Whatever the free exercise clause meant, surely it could not have been that. Thank you, and I'll turn the time over to Professor Bullock.
Thanks very much for having me. I'm very much appreciate the opportunity to be on this panel. Is it possible for me to share my screen? Well, Hmm. Any luck?
Our IT folks have the ability to help Professor Volek get his screen up?
Yes, it's here.
Okay, great.
I ask and it happens. I love it. All right, so I want to talk about some practical questions here, and perhaps one way of thinking about it, just imagine that Smith is reversed, and imagine we're back in the old Sherbert-Yoder regime. What kinds of issues is the court going to have to deal with at this point that Smith helped it avoid? Now, this does. I don't want to suggest that this is the most important question. Sort of consequentialist question is the most important one. One could certainly make great arguments that the court should just focus on the original meaning, but that's been amply handled by others, both in the panel and elsewhere. So I just want to talk about concrete practicalities, and I want to start with assisted suicide. Now, of course, there's been a claim that there's a constitutional right to assisted suicide. It was raised in Glucksberg in 1997, a companion case on equal protection grounds called Quo v. Vaco. And Glucksberg dismissed that as a substantive due process claim. It said there is no constitutional right to assisted suicide, which is to say constitutional right for doctors to be exempted from laws banning assisted suicide. And the reason it gave wasn't that there's some compelling interest in preserving life, even in situations where the person living the life wants to die and perhaps has understandable reasons to want to die. No, the court avoided all that because, of course, there's a hot controversy, both moral and pragmatic, about that sort of claim. It simply said we need not weigh exactingly the relative strength of various interests, the interest in preserving life on the other hand, the interest of autonomy on the other, because this is a matter that the law leaves to the democratic process. And in fact, as I understand it, in a few states, democratic process has resulted in favor of some amount of assisted suicide. So that was a 1997 decision. As it happens, a topic that Justice Gorsuch wrote a book on when he was when he published it when he was a lawyer. I think it's fair to say that the Glucksberg opinion is at the very least a plausible judgment, but I think probably a correct judgment that this is the sort of thing that the judges ought not be deciding. Judges ought not be the ones who decide whether there's a compelling interest in preserving life, even when somebody is dying and wants to be helped die. That there's no that the judges ought not decide whether there's a less restrictive alternative that's still effective, like, for example, requiring some doctors to and perhaps psychiatrists to interview the patient first. Some might think that's going to be effective at weeding out claims where somebody is being basically pressured to choose assisted suicide. Others might say otherwise. That kind of practical question, like the underlying moral question, should not be weighed by the justices. And of course, under Employment Division versus Smith, you'd get the same result. Of course, you'd need to even to get into the free exercise zone, raise somebody who feels they have a religious objections to ban assisted suicide. That's not hard to do. There was actually a brief articulating that argument in Glucksberg itself. There's a Colorado case in which somebody raised this argument, was rejected on Employment Division versus Smith grounds. Imagine a doctor who says, I read the parable of the Good Samaritan as requiring me to help people who ask to die, as well as people who want to live, because that too is part of God's plan. So imagine somebody like that. Under Smith, it's very easy to see how the court would resolve that question. The court in Smith specifically rejected a rule in which judges weigh the social importance of all laws against the centrality of all religious beliefs, much like in Glucksberg. So if you recast a substantive due process claim as a free exercise claim, honestly, sincerely, not just as making stuff up, there really is a religious objection there, as there is to many people about the most important things in their lives. They have religious views. You get the same result under Smith. But what happens under Sherbert-Yoder? Or under the Sherbert-Yoder rule, which is to say the rule of strict scrutiny of religious exemption requests. First question is whether there's substantial burden on religious beliefs. But again, in our hypothetical, which I think is quite a plausible hypothetical, the doctor says you are making me violate my sense of my religious duty to my fellow man by stopping me from helping him in doing something that is obviously very important to him. So there's a substantial burden. Now you must determine if the ban is narrowly tailored to compelling government interest, which means you're back in exactly the same territory that the court avoided in Washington v. Glucksberg. So to the extent that there is wisdom to the court's judgment that it's bad to have to weigh in these kinds of cases the relative strengths of various interests, that's something that is lost if you return to the Sherbert-Yoder regime. And of course, the assisted suicide is just one of many examples. One example that people had talked about for quite a while is imagine abortion rights. Imagine the court says, we don't see a right to abortion in the Constitution. We return it to state-by-state judgment. But somebody says, I feel a religious obligation, again, a doctor, let's say, who is barred from performing abortions in many states. The abortion itself, the woman is not criminally punished, but the doctor would be. The doctor says, I feel a religious obligation to try to help a patient who has perhaps prayed and gotten an answer that this is not the right time for her to be pregnant. I feel a religious obligation to help her. I too have prayed, and that is what I feel God tells me. Then in that case, they would be back to the same strict scrutiny analysis that the court, by hypothesis, might have rejected in rejecting Roe and rejecting Casey, if, again, that's the way the court ends up deciding things. Now, of course, I don't know which way the court will go on abortion rights, but again, the point is that under the Sherbert-Yoder regime, a judgment about whether something is protected under a substantive due process only affects that claim for secular people. Because after all, for religious people, if they really have a felt religious obligation to do something, then they're back in under the Free Exercise Clause, even if they don't get the claim under substantive due process. And the same thing applies to a wide range of other contexts as well. Bans on prostitution, bans on various kinds of discrimination, not just in cases like Fulton, where that's not completely clear that the discrimination is even banned by generally applicable law, but in situations where the anti-discrimination law is really quite explicit. Bans on payment of subminimum wages. There was already a case on that Tony and Susan Alamo Foundation in the Sherbert-Yoder era. That case was dismissed on technical grounds, really, having to do with the particular limitations of those religious claims, but it might be back under a revival of Sherbert v. Yoder. So that's the downside. Now, maybe you might say, well, that's what the Free Exercise Clause demands. And yes, that means that there may well be a constitutional right of assisted suicide, at least for religious people. And there may be a constitutional right to abortion, even entirely apart from the Roe and Casey situation. And there may be a constitutional right to exemption from various kinds of economic regulations. But that would be the consequence. It would be sort of a revival. Revival of Sherbert-Yoder would be a revival of aggressive substantive due process protection in a vast range of areas, again, at least so long as the claimant is religious. Now, I want to finish up by briefly talking about a second twist that sometimes arises, certainly has arisen in the briefing of the Fulton case, having to do with laws having secular exceptions. So the short version of the argument is people say, well, we'll stick with Employment Division v. Smith for laws that are really generally applicable in the sense that they apply to everyone without any secular exemptions. But once the government makes a value judgment in favor of secular motivations by carving out an exemption, then any claim for religious motivations must satisfy heightened scrutiny. And that's a plausible argument, in part because it was made by then Judge Alito on the Third Circuit. So at least one justice seems to believe in that, maybe others as well, or at least believed in it at the time. Maybe it's changed his views. So the argument would be, look, if you have a really blanket law, then no exemption. But if there are religious exemptions, then secular exemptions, like in that case for medical exemptions from a no beards policy, there should be religious exemptions too. I think the better view is the one the court articulated in Lukumi Babalu, that all laws are selective to some extent, and legislatures are barred only from judgments that governmental interests they seek to advance are worthy of being pursued only against conduct with a religious motivation. So if the government really does target only religious conduct, or it's clear that it's attempting to go after religious conduct, well, that's unconstitutional. But not just because there's secular exemptions. For instance, consider the Copyright Act. One operative section, 106, followed by 16 sections from 107, I believe, to 122, of exemptions, and that's just the tip of the iceberg. Each one has many sub-exemptions. What about the duty to testify? Look at all the exemptions from the various kinds of privileges. What about breach of contract law? What about Title VII? Now, of course, some of them actually have some religious-ish exemptions, like the clergy penitent privilege, but those are pretty narrow. If indeed the presence of secular exemptions requires strict scrutiny for any religious exemption claim, then they'd have to be applied to all these laws and a vast range of others, because very few laws totally lack all exemptions. So those are the practical consequences of adopting either Sherbert-Yoder generally or as to secular exemptions. Maybe they're worthwhile, maybe they're net positive, but that's what I wanted to flag as the issue that the court is going to have to face.
Thanks, Eugene. Now we'll hear from Lori Wyndham.
Good morning, and thank you so much for hosting this panel and for inviting me to join. I'm going to start by doing something which is pretty risky, which is to disagree with two men I greatly respect, Professor Bradley and Professor Volokh. I think Smith has failed as a standard, and I think that an exemption standard is the better rule. I also want to speak from a practical litigator's perspective here, observing what we have seen over the last few years developing in the courts. And I want to highlight two things. The first is an unintended consequence of Smith, and the second is an experiment. So the unintended consequence is shown pretty clearly in the Fulton case. This is a case where Philadelphia has really struggled to identify a neutral, generally applicable law that actually applied to Catholic social services. And it has used that to exclude the Catholic Church from foster care in Philadelphia because of its religious beliefs about marriage. I cannot imagine that the court that decided Smith thought that this was going to be the result. But the lower courts in Fulton have said again and again that they think these policies, 6 of them, are neutral and generally applicable, and that Sharon L. Fulton, a foster mom, and Catholic social services lose under Smith. I think what this shows us is that Smith has really put a heavy thumb on the scale in favor of government officials. I don't think that the way that Smith has been applied in the courts below is really in keeping with the way the Supreme Court has envisioned it and treated it. And I think the best analog here is probably Lemon v. Kurtzman. You look at Lemon and you see in the lower courts that that case held a lot of sway for a long time. I think now they're finally starting to back away from it a bit. But here you go, it's a 3-part test. We know how to do this. We're going to apply it. And lower courts continued to do that even as the Supreme Court had steadily moved away from Lemon in its jurisprudence. And I think we've seen something similar with Smith. If you look at the free exercise cases since Smith, the Supreme Court has consistently declined to apply Smith or to find that its standard was satisfied. And even though the Supreme Court has really, I would say, limited and restricted where Smith applies, we've seen in the lower courts, and Fulton here is Exhibit A, that lower courts tend to say, oh, Smith is the rule, we have to apply Smith, we have to look at this analysis, because it creates a familiar test. And so, the appeal of Smith was you have this bright line rule, you have this test, we know how to apply it, and this is what's going to happen. And unfortunately, what has happened in practice is that it has not been a bright line rule. It has been a complex and confusing standard that the courts haven't really known what to do with. And so, as Professor Volokh alluded to, you have this confusion over when is a law generally applicable? Is it enough to show that you have a system of individualized exemptions like you had in Sherbert, or do you need to also show there's some kind of discrimination in how that system is applied? Or is it enough to show that there are some secular exemptions to the law? Or do you need to show that it's really targeted at one particular religious belief or religious claimant? Is it enough to show that the law was crafted and created in response to religious exercise, like some of Philadelphia's policies have been here? Or do you need to show more than that? Do you actually need to go beyond that and show proof of animus? And now we have a circuit split over exactly those issues. And that to me really sums up the unintended consequence of Smith. Instead of clarity, you have confusion. And what has happened is that a lot of courts, especially if you look at the Lukumi decision and the really egregious discrimination there, have treated Smith as purely a discrimination standard. It's not about whether the law is neutral and generally applicable. It's about whether it is targeted at you. And I think the daylight between those two things is actually pretty significant. And so the direction that these free exercise cases have gone, which I don't think the Smith court could have foreseen, is that it has created an incentive to look at the lawmaker's heart of hearts and whether they're trying to target religious people. And so you have this rummaging through the legislative history and the rules that the justifications for the rules that are being applied, instead of actually looking at the law on its face and making an objective determination about whether it fits within the Smith rubric. I don't think that's something the court foresaw in Smith, and yet it has been how a lot of these cases have ended up turning out below. And so what promised to be simple has proven to be complex. And I think that that is a key point here. As Professor Bradley acknowledged, Smith wasn't premised on originalist evidence. There have been attempts since then to close that gap. But really, Smith was premised on a prediction about what was going to happen with free exercise law, that it would be courting anarchy if you had these exemptions. And that was the central premise of Smith, which is what brings me to the experiment. We've had 30 years now since Smith to run that experiment, and it turns out that Smith was wrong. Our states are the laboratories of democracy, and they've been running this experiment for us. About half the states have either religious freedom restoration acts that impose an exemption standard rather than a Smith standard, or they have interpreted their own state constitutions in a way that is more friendly toward religious exemptions, more protective of religious exercise than what you had in Smith. And what we found is that if you look at some of the scholarly research on this, like what Professor Lund has done, that actually it's a relatively small number of cases that have been decided. And the states have generally been pretty happy with their ability to legislate and regulate even under these symptoms. We had even under these circumstances. And we actually had a number of states come in the Fulton case and support our side and say, yeah, get rid of Smith. We want a better standard. This standard has actually worked for us. And we've seen a similar dynamic at the federal level. Of course, the federal government came in and passed RFRA with an overwhelming bipartisan majority, if anyone can remember the days when we did such things. And it originally applied everywhere. And of course, in Bernie, as we all know, the Supreme Court cut that back. But since it has applied to all federal law and applications of that law. And yet, tests and research on this, like that done by my colleague Luke Goodrich, have shown that still RFRA cases are a pretty small part of the federal caseload. And the same is true for cases under RLUIPA, which applies at both the federal and state levels to land use issues and to prisoner cases. And so what we have seen over 30 years of history is that this exemption model actually works very well and has proven to be a manageable system. And I think that's true for a couple of reasons. One is that you do have, in many cases, a burden standard. So it's not just, I'm a religious person and I have this policy preference. It is, you are actually burdening me. You're actually forcing me to do something that my religion forbids, or prohibiting me from doing something that my religion requires. And so I think that that really narrows the class of cases that you see. And when it comes to the compelling interest analysis, what we have seen is that courts have been able to apply that test very well and to figure out when it is that an exemption is really compelled. And I think, one final note on this, I've said the word exemptions a lot. We aren't talking about exemptions. You can still have a policy. You can still have a rule. You can still have a law, and you can still apply it in the vast majority of circumstances. We're talking about that much narrower class of circumstances where it really does restrict or prohibit someone's religious exercise. And in those cases, courts have been able to strike sensible balances and determine where that is warranted. And so my thesis here is that Smith is an experiment. We have now run that experiment for 30 years and Smith has failed. And so I'm happy to turn it back over to Judge Rao and look forward to some more discussion.
Great, thank you. Thanks to all of our panelists. For those of you who are watching, feel free to raise your hand if you'd like to ask a question. But otherwise, I'm going to kick it off with a question to our panelists. So Professor Barkley mentioned that there wasn't really any original understanding of what religious exemptions might look like in a large welfare state. And in the Becket Fund's brief, they talked about the fact that Smith didn't really contemplate a world in which we had a significant amount of government by regulation. And certainly in my previous experience working in the administration, I've learned it's much easier to impose religious burdens through regulation than it is through legislation. And we live in a world which has an ever-expanding administrative state and, much less lawmaking. So I guess I'm wondering, maybe this is in particular a question for Professors Bradley and Volek, but I'd be interested in what all of you think. What is does Smith have less purchase in a world in which so many of these rules are really regulatory rules as opposed to laws enacted by the legislature? And, and what can we take from that?
Well, I'll go first and give Jean a little bit more time to think. Judge Rao, I think I appreciate the force of your question. I'm not sure what it means quite to say that Smith doesn't have as much purchase as it should, or as one might wish it did. And I say that especially because Smith really stands for a very limited, or much more limited, judicial intervention in an emerging religious culture in an administrative state than the compelling state interest test does. So what I mean to say is that Smith leaves wide open the capacity of legislatures, administrators, and others to confront conditions that the founders couldn't have contemplated. I agree with that. But I haven't so much heard arguments today that persuade me that handing over in a wholesale way the problem of contending with a modern administrative state to judges, which judges have already saddled themselves with a sort of set of value judgments having to do with what are called dignitarian harms. And judges who, by and large, in all due respect to you, Judge Rao, have a poor to very poor understanding of what religion is. My judgment is that on the whole, it's not a promising prospect to decide to transfer jurisdiction for conflicts, if you want to call them conflicts, between religious conscience and the administrative state to unelected judges. And even, many of the cogent or certainly reasonable arguments that both Stephanie Barkley and Lori Wyndham make about Smith, even if Smith is in some respects a failed experiment, it doesn't follow that the alternative, or the only alternative, is sherbet. In other words, there's a non sequitur there. I teach Smith every semester, and its meaning at times eludes both me and my students. So I wouldn't quarrel with at least some of what Lori and Stephanie say. It doesn't seem to me that changes the meaning of free exercise, nor does it follow that somehow if Smith has not worked well, sherbet is the alternative. There are many other alternatives.
I'd like to yield my time, such as it is, just to get to more questions, but I think that Professor Bradley's analysis seems quite sensible.
Can I add one short thing to what you pointed out, Judge Rao? Professor Philip Hamburger filed a brief in Fulton and has written a law review article about this issue. And I think what he thinks is important, given that again, Justice Scalia was relying on Professor Hamburger and his city of burning concurrence. But what Professor Hamburger has said is that Smith rests on the political logic that religious Americans can protect themselves from oppression under equal laws by engaging in politics. And this is a Notre Dame Law Review article he's quoting from in his brief. And he says that this expectation that religious Americans can engage with their lawmakers does not reflect the current realities of American lawmaking. And then he goes on to describe how, as you said, so many of these burdens on religion are coming from unelected bureaucrats, and this profusion of administrative policy creates a profound inequality. So just to underscore the point that you were raising, that whatever Smith's merits, it seems a particularly poor fit for the reality that the administrative state now, when it relied on the idea that exemptions would be provided legislatively through democratic engagement that often doesn't exist at that administrative level.
Lori, did you have any thoughts about that question, or?
No, I'm happy to yield and move on to the next question.
Okay, sure. I'll just remind the audience, if you have a question, just raise your hand using the chat feature in Zoom. So I guess, something that was, implicated in some of these remarks is whether it's possible to understand Smith in a more tightly constrained or narrow way, right? As really focusing to see whether a law is genuinely neutral and genuinely generally applicable. I think Justice Alito suggested such an approach in his dissenting opinion from the denial of cert in the Stormans Pharmacy case. He noted that a law that discriminates against religiously motivated conduct is not neutral. And he also argued that if a regulation appears neutral, but in fact is, he used the word gerrymandered in a way that it discriminates against religiously motivated conduct, then that should receive strict scrutiny. So I guess I'm wondering what your thoughts are. If the court were to, read Smith more narrowly, would that satisfy some of these concerns? And I guess, would that be a faithful reading of Smith itself?
So I think the answer is no. And I think in some respects it would be worse if the court goes beyond what it said in Lukumi. So in Lukumi, basically, you had a law that banned animal sacrifice, but all sorts of killing of animals was allowed for food, for hunting, generally allowed. And it looked like all it was going after, there was evidence from both the legislative history and the practical effect of the law, all it was going after was religious conduct, religiously motivated animal sacrifice. That I think is quite clearly this sort of gerrymandered attack on religious practice alone. But let's look at the case that Justice Alito wrote about this at the Third Circuit level, the one that I quoted the line from. That had to do with a no beards policy, which I think applied to a lot of men who like to wear beards. I'm not one, but I'm told that many do. But had an exception for medically required beards, because as I understand it, some men, mostly Black, have a condition, I want to say it's pseudofolliculitis barbae, which means that if you shave, you end up getting skin infections and ingrown hairs. So there is an exemption for that. And the court said, aha, because of that exemption, there also needs to be an exemption for people who have a felt religious obligation to wear beards. Well, that certainly wasn't a rule that was targeted at Orthodox Jews and Sikhs and, say, Muslims, the groups that most commonly require beards, maybe some Eastern Orthodox, I'm not sure. But in any event, that clearly wasn't so. So there wasn't gerrymandering in the sense of deliberate targeting. Now, it's true that a secular reason for action, medical concerns, or essentially the reason was avoiding medical problems, was treated more favorably than religious reasons and all sorts of other reasons. But again, that's true in a wide range of other laws. So the problem is either that's going to be a way of essentially saying, oh, we're preserving Smith, but not really. We're not at all preserving Smith. Or given that almost all laws have some sort of exemptions for even the homicide law has exemptions, right, for self-defense and a few other situations. So then there'd have to be judges deciding, well, this law is general enough, but this law isn't general enough. Not just that it's the question of whether it is targeted only at religion, but whether it's targeted mostly, partly enough on religion. That will end up being kind of this mushy standard that will allow judges to essentially trigger strict scrutiny as to laws that they don't much care for, and not do that as to laws that they like by using this very indefinite standard of whether there are enough exceptions. So given the choice between that and Sherbert and Yoder, I would prefer Sherbert and Yoder, because there, at the very least, there would be a pretty clear strict scrutiny standard. But again, if we do that, then then there really would be calls for exemptions from all these laws. And here's one extra twist. One defense of the Sherbert-Yoder regime is, well, the government can still win under strict scrutiny and often does win under strict scrutiny. But if you really are attentive to the exemptions, then a common argument, which of course is commonly raised when strict scrutiny claims are litigated here, is the law is under-inclusive. Look at all these exemptions. The very fact of these secular exemptions shows that the law is not narrowly tailored because it's under-inclusive. It's a very familiar argument from equal protection context, from speech restrictions, cases like Florida Star BBJF and the like. So the consequence may be that we would have really aggressive strict scrutiny standard with a lot of teeth to it. And the result will be all of these exemptions, again, for religious objectors, not for their secular, conscientious objector analogs. I think that the court ought to resist that. And I think if confronted with some of these examples, like in the assisted suicide context and such, I think the justices probably would resist that.
Thank you. Does anyone else have any thoughts? Or
Sure, I'm happy to jump in there. I think that I think this is a great argument for something that looks more like a RFRA standard than a Smith standard. But I would say that I think what's important here is when you're looking at what these exemptions are, that you're looking to, is the government now getting in the business of making value judgments? And this is the language that Smith uses when it's talking about individualized exemptions. It's talking about whether a law is directed at religious exercise or whether there's a system of individualized assessments. And I think those are two separate flaws that might lead you to strict scrutiny. But I think that both get to the same issue, which is the government has decided, okay, we don't actually have to apply this law across the board. We're going to apply it sometimes and we're not going to apply it other times. And we are in the business of making these value judgments about when the law is important enough to enforce and when it isn't. And when the government does that and decides that other things are more important than a fundamentally protected First Amendment right, then I think the right answer is to put the government to its proofs and to say, okay, you did make a distinction here. Is that distinction justified? And I do agree that in Lukumi, in a case like that, where Hialeah's laws were just completely a mess, and it was okay to have, hunting and fishing and euthanasia and all these other exemptions, but not an exemption for a century of sacrifice, that there was no way they passed the compelling interests test. But there are other cases where the government may have a very good reason for saying, no, this is why we have to allow this exemption, but not this one. The question is, can you put them to the test? And I think the right answer is to go ahead and do that, and to make sure that when you do have a fundamental right at stake, that is going to be protected. And I do think the question in those kinds of exemption cases is it actually an exemption? We've heard, criminal law and other hypotheticals. I think it's a different question when somebody's just missing an element of the offense, as opposed to when you're really saying, okay, we have an individualized exemption system set up for murders. If you want to commit a murder, come to us and we'll tell you if you get an exemption or not. I mean, it's a laughable construct, and yet that's exactly the kind of exemption system that we see with regard, in many cases, to administrative law and other kinds of systems where the government really is making subjective determinations.
Can I just chime in for just a moment, because I think that's
and then we're going to move to audience.
It's such an excellent example. There is a individualized exemption system with regard to murder, and that's the law of manslaughter. That certain kinds of provocations downgrade murder to manslaughter. They don't make it make it non-crime, but they do dramatically affect both the level of punishment and the label that's used for the crime. It makes a different crime, manslaughter. Now, a few states have basically very hard and fast rules that certain kinds of provocations count and certain don't, although those are the results of value judgment by judges. But some of them just generally ask, as a matter of law, whether something counts as a reasonable provocation and allow judges to come up with new categories. So my question then would be, does it follow that the Free Exercise Clause requires judges to treat religious reasons for killing as positively as as the favored secular reasons. So a classic example is somebody is entitled, I'm not entitled to kill, obviously, but somebody's entitled to a diminution from murder to manslaughter if the person is enraged by seeing their spouse having sex with another person. Does it follow that there needs to be equal treatment for somebody who's enraged by seeing somebody blaspheme against God? Another example is necessity. Now, in many states, perhaps most states, necessity is not a defense to the charge of homicide, but it is a defense to various other charges. Like there's a necessity defense to trespass, that if somebody trespasses on my property, but there's a reason, like for example, they're trying to rescue an animal that has wandered over onto my property, then in that case, there's sort of case-by-case decision-making. Does it follow that when somebody is trespassing on my property because they believe there is some visitation, say, of the Virgin Mary on my property, and they feel an obligation, assume they sincerely say they feel an obligation to go and make pilgrimage there, that they are entitled to the same treatment under this case-by-case decision-making through the necessity defense? I'm inclined to say that they shouldn't in either situation, and that the law can quite reasonably say judges will develop a limited set of secular exemptions, essentially, under this general rule of provocation of necessity, and we need not treat religious reasons for violating the law, whether it's against homicide or against trespass, the same.
Okay. I'm being asked to mention the CLE password for those of you who need CLE. It is FED20, FED20. And Stephanie has a brief response to this question as well, and then we'll go to the audience questions. Thanks.
Just one brief response to what you're talking about, Eugene. This question, how do we compare the different types of exemptions, and should the religious one be treated the same as the secular one? I think you're highlighting why that type of analysis is ill-suited to a preliminary step of just deciding whether a law is generally applicable or not. Because in order to really understand the answer to that question, we have to have criteria by which we're measuring the similarity of those types of exemptions, which is what the government interest is. And frankly, often we'll need some sort of an evidentiary showing of the extent to which a secular versus a religious exemption is undermining the government interest. Strict scrutiny is suited quite well to that question. We force the government to identify its criteria, its government interest, and then the burden is on the government in an evidentiary way to demonstrate whether or not a religious exemption might undermine its interest more than a secular exemption. But there's nothing comparable to that in any sort of predictable evidentiary way at the preliminary general applicability step. There's nothing facially obvious from a statute that would answer that question, which is why I think that the problem Justice Scalia, I think, was understandably trying to avoid, it has just been made more confusing by trying to truncate that analysis into a space where we don't actually have the tools to get at the right answers. I think RFRA, on the other hand, which does provide a way of getting at those answers, avoids some of the concerns that Justice Scalia had about balancing the centrality of religion to the importance of the government interest. We don't do that sort of balancing under RFRA. We just ask, has the religion at least been burdened? And then we ask if the government has identified an interest that it's actually advancing.
Thanks. Okay, I'm going to move now to the audience questions. We have about 15 minutes left of the panel, so I'd appreciate if the speakers could keep their questions brief. So I'd like to recognize Michael Rossman. If you could just unmute yourself and identify your affiliation and ask your question. Thank you.
Michael Rossman, I'm with the Center for Individual Rights. I have a question for Eugene. Ms. Wyndham, Eugene pointed out that we're living in a country that has many Sherbert-Varner jurisdictions. I assume some of them prohibit assisted suicide and some of them prohibit, say, late-term abortions. Have there been any challenges of the kind you identified in your presentation? And if there haven't been any such challenges, could you take a guess as to why not?
Sure. So I'm very glad you asked this question, because for a long time I was pretty much the only academic who on one hand thought employment division versus Smith was largely right, but on the other hand thought that RFRAs, state-by-state RFRAs and the federal one as to federal laws were also a good idea. So one thing that I like about religious exemption regimes that are done on the state-by-state level is that the courts don't get the final say there. They get a say, which is actually quite sensible. If you look at this balancing of interests, that's something the courts have historically done in developing the common law of tort, of property, even of crimes. But that's always been subject to legislative modification. So a legislature could, if it finds it doesn't like a court's decision as to carving out an exemption, it could say, well, we're going to revise that, not in that particular judgment, but going forward, we're going to exempt this law from RFRA. So to turn to your question, as to assisted suicide, such a claim was made. It was made in Colorado, which is a state that doesn't have a state RFRA, and its state constitution has not been interpreted to follow follow Sherbert and Yoder. So the claim was made and it was rejected under Smith. I do not know whether it's been made under RFRAs in other states. I think part of the reason is that with a lot of these things, I think these are creative arguments that a lot of lawyers don't really raise. A typical lawyer in a state like Texas, let's say, to give an example of a state that has a RFRA, may not really be thinking in those terms, and especially if they've seen this decision is called Sanderson. From Colorado, the one-line summary is no religious exemptions from assisted suicide laws, may not really think about how the Texas RFRA might play out. What I think often happens is there's something of a snowball effect, that you start out with relatively few claims under some rule because people don't really know about it. It takes lawyers to know this. And then as people learn about it, and as religious rights litigation groups become more common, like Beckett, which I very much admire, but also at various state levels, then you get more and more of these kinds of claims. So, for example, for a while, one might have thought that there wouldn't be much by way of religious exemptions claims from anti-discrimination laws, especially when they were roundly rejected with regard to employment discrimination in the 1970s. But then around the late 1990s, you began to see a lot of them as to housing discrimination laws and marital status discrimination, even though marital status discrimination bans had been around for some time then. As to abortion, there's no need for a religious exemption claim because Roe, as modified by Casey, is still the law of the land. I was raising a hypothetical example about what would happen if Roe and Casey were reversed on the grounds that a constitution says nothing about abortion. Would somebody then say, well, Constitution does say religious exemptions, assuming you're back to the Sherbert-Yoder regime? And there, I'm quite positive there would be these kinds of claims, because that was an argument that was already made around the time that the original RFRA was enacted in the early 1990s, that it's well known in kind of the abortion rights space that this is a possible potential argument. It's just there's no occasion to raising it yet. So that would be my reaction.
Thank you. Okay, next we will go to James Odom. If you could just unmute yourself, please. James Odom. Okay. How about Sean Ross, if you could unmute yourself?
Not a signal to unmute.
Hi, this is Sean Callahan. Yeah, so is there a way to bring back religious accommodations under the exercise clause without overruling any currently enforced case, which might be a prospect Chief Justice Roberts would warm to? Isn't that way something Professor Barkley mentioned? She used the term actually advance. I use the term directly advance, and so the nub of the question is, doesn't Yoder survive Smith through Lukumi for this reason? When you look under Lukumi, we talk about it as a targeting case. When you look under the hood of Lukumi, as you discussed, yeah, it really gets to the targeting conclusion through a various means ends looks at the law and the the statements, the legislative statements in Lukumi were kind of ancillary. So if you do that and you look for law accommodations that you can provide that do not interrupt a challenge law from directly meaning if the accommodation, if taking away the accommodation does not directly advance a state interest, doesn't that draw a line through and then granting the accommodation in that case, doesn't that draw a line from Yoder through Lukumi without overruling Smith?
Lori, do you want to take this one? I can take this one if no one else wants.
Yeah, sure.
Okay. I think that there are ways to interpret Smith that would really narrow its application. You mentioned an interesting one. If we sort of expanded the notion of Lukumi as focusing on whether or not the government's actually advancing its interests or not. Another one that I think is interesting which is relevant to the Fulton case, is that Smith itself relies on the idea that there are going to be laws that are incidentally burdening religious exercise. And for a law to knowingly burden religious exercise, that's not the same as targeting or discriminating or having animus against religious people. That's just sort of being on notice that you're burdening religious exercise and doing it anyway, which the city of Philadelphia definitely is. Every year when they renew this contract now, they have an opportunity to accommodate the religious exercise of the Catholic foster agency, and they choose not to. And one reason that knowingly burdening religious exercise or knowingly excluding them from government programs is concerning potentially is it raises the same sorts of concerns that we have about things like standard licensing in the speech context. When the government has all of the discretion, this is a constitutionally suspect system because it can so easily be abused. And this goes to a point Judge Rao made earlier. Most of the religious exemption conflicts aren't coming up with a law that was passed 10 years ago and the legislatures just weren't thinking about religion, and now we have this burden coming up. These conflicts are coming up in contexts like this one in Philadelphia, with government bureaucrats working on the government contracts, but also in other administrative contexts where the officials are on notice and through the administrative process could easily, sometimes with the flick of a pen, accommodate religious exercise. And so it's also plausible that you could imagine a world in which Smith, just by its own logic, doesn't apply to those sorts of contexts. And that would be a way of not overruling Smith, but cabining Smith to the reasoning that underlied its holding.
Can I ask a very quick question as a follow-up? So in Smith itself, the state of Oregon was well aware by the time the case reached the Supreme Court, obviously, that the ban on peyote affected certain American Indian religious groups. Now, it may be that at the time that the legislature enacted it, they were unaware of that, although perhaps they were aware of it. The use of peyote, I think, had been around for quite a while, and American drug laws don't date back to the framing or the time that Oregon joined the Union. But let's assume they didn't know it, but now they know. Now they know, and maybe they've amended the law since then. So they've touched it since they've known this. So how would that affect things under your reasoning?
Well, so let's bracket for a moment that Smith itself had this system of individualized exemptions when we're dealing with employment law, which I think made Smith, a poor vehicle to try and distinguish from a case like Sherbert. Let's bracket that for a moment and just look at the criminal law. I think that it is a fair point to think about laws that have been passed legislatively. It is more difficult and cumbersome for those to be amended. And so the reasoning as far as government needs to be able to pass legislative laws and move forward and do its work has more weight there. I don't think it's fully persuasive, but it certainly has more weight in that context than where through the administrative process, policies can be amended much more easily, especially if we're not even talking about a notice and comment regulation. Something like a contract requires no burdensome process to add an amendment to. So I just think that the ease with which government officials can either accommodate, or the negative flip side of that coin is exclude religious groups from public society and from different programs, makes it more suspect if we're giving those government officials a lot of discretion and the ability under the flimsiest of excuses to burden religious exercise.
It is an interesting feature of the administrative process that it is easier to grant exemptions, just as it is, as you said, easier to burden religious exercise. And the Supreme Court has upheld those exemptions, right? The religious and moral exemption regulation that was upheld in the Little Sisters of the Poor just this past term, which was upheld by 7 votes on the Supreme Court. So that could be an option as well. Okay, next we will go to a question from Christopher Melling. If you could unmute yourself and ask your question, please.
Yes, thank you. I don't know if Professor Bradley dropped off. I was going to ask him to expand on his comment that if the court wanted to overrule Smith, it would want to wait for a less provocative case. But if he did, in fact, drop off, I just wanted to expand that. I know not everybody here would like the court to overrule Smith, but could you envision a better vehicle in which the court might have a stronger argument or tend to overrule Smith? Is there a current case percolating right now or something that you envision causing that? Thank you.
So yes, Professor Bradley did drop off. So do any of the other panelists want to respond to that question? No. Eugene, do you want to go?
No, I don't know what cases are in the pipeline, but I can certainly see that this case has all sorts of other, both, among other things, arguments for why this particular law should be not so much struck down, but an exemption should be granted that don't require overruling of Smith. And my guess is that the justices would rather go with that than with full-on overruling. Yeah, I think we've got an email from Professor Bradley. He was having technical problems and couldn't reconnect.
You could imagine that the court might want to take up the Smith question in a vehicle where they're not having to deal with some of the contracting issues. That might be one reason why. There are cases in the pipeline right now where secular exemptions or some of the targeting might be less part of the facts. I think Beckett has a petition, a Rick's case, where the Supreme Court has more maybe directly teed up before it whether or not to overrule Smith. It doesn't have as many easy outs, so to speak. So there are other options that might be on the court's radar. Whether or not they prefer those to this one, I can't really speak to that.
Okay, just one more time, the CLE password for those of you who need it is FED20, FED20. And I think we have time for probably one more question. So we'll go to Maritza Bolano. If you could unmute yourself. I think you're still muted. Yes, please go ahead with your question. Okay, I think we're okay. We'll go to Walter Weber. If you could unmute yourself. Oh, maybe. No. Okay, we will go to Nick Venable. If you could please unmute yourself.
Yes, I was. Can you hear me?
Yes, thank you.
Great. I was just wondering, in the oral arguments for Fulton, it seemed like several of the justices were interested in recognizing a compelling state interest in eradicating discrimination against same-sex marriage. I'm wondering to what extent will just a combination be possible at all if they did that? Sort of what's the route forward for religious liberty in that scenario?
So I'm happy to speak to that. We've seen now 3 instances where the court has recognized the sensitivities inherent in the marriage context. They noted that in Obergefell, saying there were decent and honorable religious and philosophical beliefs on the other side. We saw it again in Masterpiece, where they acknowledged that if, say, a member of the clergy were unable to solemnize a same-sex marriage, that was a kind of religious exercise that gay persons could accept without diminishment to their own dignity and worth. And we saw the language in Bostock just last term about the free exercise being at the heart of our pluralistic society. And so I think that that shows the court has been very much aware of the need here to not extinguish a particular set of religious beliefs or not exclude those from the public square who have those beliefs. And I'd also point back to cases like Hurley. You know, Hurley was a non-discrimination ordinance, public accommodations ordinance, and yet the court recognized in that case that the existence of that did not overcome freedom of expression and association. So I think that that shows that courts have been able to strike these balances and to look to how the test is applied to the person and to the particular religious exercise at issue in that case, rather than just saying, nope, this is all the time and forever excluded.
So this is
go ahead, Eugene. You go first. I'll go after.
Sorry, I just wanted to say, this issue has come up in the free speech context in Hurley and in Dale, the Boy Scouts case, which involved expressive association. And the court basically kind of fudged the strict scrutiny analysis. I'd say it applied maybe more than strict scrutiny, but basically it said, look, we understand you have, the state claims a compelling interest in preventing sexual orientation discrimination. It's not enough to overcome the free speech rights here. But note the importance of Hurley, of the free speech context in Hurley and Dale, is that narrowed the range in which there would be an exemption from anti-discrimination laws to basically expressive association or parade, sort of organizing your own speech product. Likewise, one possible argument that I actually endorse in some of the wedding service provider cases, although not in Masterpiece, which involve bakers, is as to say photographers and such should be a right to freedom from compelled speech, and that there should be an exemption from generally applicable laws indeed there. But again, note the narrowness of that. That's limited to the free speech context. If you accept it, it seems to me, if you accept this kind of exemption in Fulton, I think that would apply to a wide range of public accommodations, to be sure. It's not exactly a public accommodation in Fulton, but it's close enough, I think, in many ways. Wide range of government contractors, because I don't think there is as easy a way of cabining that as there is when you're talking about specific targeted individual rights like free speech. You're talking about a claim of exemption from generally applicable laws. It could apply to a vast range of, in this case, of anti-discrimination laws, and it becomes quite difficult for the courts then to say, well, foster parent placement agencies are on one side of the line versus, let's say, providers of limos or of hotel space for weddings are on the other side.
Yeah, we are a little over time, but if Stephanie, if you want 30 seconds, and then we'll just wrap up.
Okay, the 30-second wrap up is, first, in response to this concern we often hear about religion not being cabined and speech being cabined, in an article that my friend Mark Rienzi and I wrote in the Boston College Law Review, we surveyed speech versus religious claims, and speech claims are actually a much higher percentage of the federal caseload than religious exemption cases are. So I don't think that concern about cabining religion is empirically founded. I guess number two is, I would say, even in the context of race, the very, very important context where the government might be operating at its zenith when it's prohibiting race discrimination, in the speech context, sometimes we have said that First Amendment rights overcome that interest, in Virginia versus Black, in Skokie. And so I think it's important to remember that when the government has a compelling interest, that doesn't give it a trump card to run roughshod over First Amendment rights. We still have to look at, is the government's application of that interest in this particular case being advanced in an even-handed way? Are there less restrictive ways that the government could accomplish its interest? That's certainly true with religious exercise about other sort of interests, not touching on race as well.
Okay, thank you. I want to thank all of our panelists. Professor Bradley joined us back by phone. Thank you all for your great comments, and to our audience for their questions and for joining us. I just want to let everyone know that the next convention panel will start at 12:30, and it's a discussion of the EPA turns 50, a debate on environmental progress and regulatory overreach. So if you'd just join me in thanking our panelists. Thank you.
Thank you, Judge Rao.
Yeah, thank you.
Thank you very much.